President.
Senator Forgan.
Mr. President, everything that has happened since the untimely passing of the legendary Justice Ginsburg is a clear reminder that much of what goes on in Washington, D.C. is simply not on the level. Right now, our country is hurting. Mass death, mass unemployment, mass hunger and suffering among children. The two sides in Congress ought to be addressing those challenges together. Now more than ever, while so many are so fearful about tomorrow, the rules that the Senate goes by and the agreements the Senate makes need to stand for something. That's how I felt when I negotiated for the $600 per week unemployment insurance boost in March. The Treasury Secretary for the Republicans agreed to it. But then at the last minute, Republican senators pretended otherwise and tried to vote it out of the bill. Think about that. There was an agreement between both sides. And the one thing that Senate Republicans wanted to do was to break the agreement and keep workers from getting that extra money to pay the rent and the food bill at a time when they had been laid off through no fault of their own. Another example is unfolding right before our eyes. Until a few weeks ago, Leader McConnell and Chairman Graham would have told you it was essentially the 11th commandment carved in stone. No election year Supreme Court appointments. Again, Republicans went back on their word. If the cure to COVID-19 was partisanship and rule breaking, then Senate Republicans might be on to something with their low stunt on the high court. But it's not. Now, the American people have a much more sensitive radar for unfairness than Senate Republicans. When I was home during the 2-week period here recently, I went to counties that Donald Trump won decisively and counties that Hillary Clinton won in 2016. Folks I talked to in both communities, in both areas, said the person who wins the 2020 election should be the one that chooses the court nominee. And in this case, the American people know what's at stake for them because they see the consequences of rule breaking. If Judge Barrett is confirmed and does what Donald Trump has repeatedly said he requires of a nominee, help him throw out the Affordable Care Act, here's what happens. Tens of millions of Americans will suddenly lose their health care during a pandemic. COVID-19 becomes a pre-existing condition used by insurance companies to once again discriminate against consumers, take America back to the days when health care was for the healthy and wealthy. Even the nominee herself shows this process on judicial nominees is so dysfunctional and so broken, it doesn't come close to being on the level. Amy Coney Barrett may have established herself as the Babe Ruth of saying pretty much nothing. Now, everybody understands that nominees typically clam up during these hearings. I don't expect Judge Barrett to disavow Trump health care policy. I wouldn't expect to agree with all of a Trump nominee's positions. But unfortunately for our country, this hearing was a new low. For example, one of my colleagues asked whether Judge Barrett was aware that the president had committed to nominating judges who would throw out the Affordable Care Act a statement that was part of news accounts all across the country again and again and again and again. Back in 2015, Donald Trump said, and I quote, "If I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare," unquote. The day after Judge Barrett's nomination, Donald Trump tweeted, and I quote, "Obamacare will be replaced with a much better and far cheaper alternative if it is terminated in the Supreme Court." But Judge Barrett answered when my colleague asked about whether she had heard about anything resembling Donald Trump's views on this. She said, and I quote, "I don't recall hearing about or seeing such statements. That wasn't something that I heard or saw directly by reading it myself," unquote. She also said she couldn't recall whether senators brought it up during their conversations with her. So I say to the Senate today, does anybody think that was an authentic answer? Everybody who occasionally looks at the news knows that Donald Trump wants to tear down the Affordable Care Act. He famously promised the far right that his judges would take all the far right positions. He routinely attacks Republican-appointed justices for opinions that he dislikes. The never heard it, never saw it argument advanced by Judge Barrett, that she doesn't follow the news apparently at all, didn't talk with anybody about the health care debate that has been front and center in American politics for a long, long time, is hard to mesh, and I understate this, with reality. You don't reach the heights of the academic and legal profession by ignoring the news of the day for years and years and years on end. So if you watch Judge Barrett's hearing, it's clear what this never heard it, never saw it argument is all about. It's about denying that there is any real threat to the Affordable Care Act, to protections for pre-existing conditions, to cheaper medicines for seniors. Judge Barrett certainly put on a Hall of Fame performance in ducking and dodging and weaving her way out of even the simple, routine questions about existing law, the stuff that's guaranteed to come up in every nomination hearing. For example, and this one just stunned me when I heard it, she wouldn't say whether Griswold in Connecticut was decided correctly. That is the landmark 1960s case that affirmed the right of married women to have access to contraception. It's one of the key Supreme Court decisions that gets directly to the right of privacy and to the rights of women to make decisions about their own bodies and their own lives. The decision in Roe versus Wade follows directly from the decision in Griswold. Even Justices Thomas, Roberts, Alito, and Kavanaugh, not exactly the left wing of American judicial considerations, said Griswold was decided correctly. Judge Barrett refused. And that matters because there is a far-right campaign working to undo both of those decisions, which would be devastating to a woman's fundamental freedoms in our country. She dodged serious questions on the legality of in vitro fertilization, which has helped millions of parents achieve their one dream, having a family. The judge refused to say whether she believed the landmark decision on marriage equality was decided correctly. The one case she was asked about enshrined marriage equality. She dodged a question on whether U.S. presidents should even commit to a peaceful transfer of power. She went on to say voter intimidation. On the issue of voter intimidation, she wouldn't answer whether it was illegal. That's not an open question. It's a case of black letter law. She was given what I thought was a slam dunk opportunity to confirm that a president cannot unilaterally change the date of the election. That one's not open to interpretation. The law is clear that he cannot. Judge Barrett wouldn't say so. Mr. President, it's not like this nominee has been shy about sharing her views. For example, she bashed the opinion by Chief Justice Roberts that upheld the Affordable Care Act. She said, and I quote, "It pushed the Affordable Care Act beyond its plausible meaning to save the statute." That decision is the reason that 130 million Americans with pre-existing conditions are protected today, why insurance companies can't impose caps on people who need costly health care, why seniors no longer get stuck in the prescription drug donut hole, bankrupting their savings. Judge Barrett put her name on a letter that talked about overturning Roe versus Wade because it was about a barbaric legacy. She also lectured on the subject. She failed to disclose the letter and some of those lectures in her disclosures to the Judiciary Committee. Again, I understand that nominees are always careful in these hearings, but nomination hearings are providing less and less substance. That's been the case for a long time. And over the last few weeks, Judge Barrett set a new low. Years ago, Chief Justice Roberts talked about the job of a Supreme Court justice and said it was about calling balls and strikes. My question is, how can you be trusted to call balls and strikes if you spend your nomination hearing playing hide the ball? This rush job doesn't qualify as advice and consent. In my view, you look at Donald Trump and Republicans rushing this confirmation, you look at all the ducking and dodging of basic questions, and it's not hard to see the politics behind it. At a moment when there are millions of Americans across the country wondering how they're going to pay the rent, how they're going to afford medicine, whether they're going to be able to safely hug their elderly parents again, Senate Republicans are laser focused on locking in political power in the courts. That's what this is all about. Senate Republicans somehow think this is a Houdini Act, suddenly making the threat to the Affordable Care Act disappear. It's not working. And my view is the American people understand that the rush to fill the Ginsburg seat is about a lot more than health care. Republican nominees for the courts always come before the Senate and talk about how it's the text of the laws as written, respecting precedent, respecting the original meaning of the Constitution. What happens when they join the bench? They throw out longstanding precedents, restrict individual rights, push forward with an agenda that favors special interests and the powerful. For example, Judge Barrett gutted a consumer protection law from the bench by essentially ignoring the text of the law itself, making it easier for debt collectors to prey on the vulnerable. Judge Barrett threw out precedent to deny $332 in damages to a woman who was injured in a medical procedure. The woman was actually unable to afford a lawyer, and she mistakenly used the wrong word to describe the money she was owed. Judge Barrett used that mistake against her. She ignored another existing precedent to take away a jury award from a teenager who was repeatedly raped by a prison guard. She sided with a company that segregated employees by race. In another case, she came up with a twisted interpretation of the Age Discrimination and Employment Act to allow discrimination against older job applicants. None of that had anything to do with calling balls and strikes or respecting the laws as written. Those rulings favor the powerful and corporations over people who don't have clout and don't have vast sums of money to protect themselves. President and Senate Republicans have packed the courts from the top on down with far-right judges who excuse these kinds of ideological rulings. They blocked Democratic judicial nominees for years. They had a plan to remove seats from the D.C. court rather than considering the sitting Democratic president's nominees. Now the president has pushed through an immense number of nominees, given how many seats Republicans left open through obstruction. Some of these judges have been deemed not competent for the job by nonpartisan legal groups. It's done incredible damage to the legitimacy and the independence of the judiciary. And virtually all of them tell the same story about originalism and sticking to the text in the tradition of Justice Scalia. Justice Scalia is considered to be the ultimate example of what is considered originalism. Judge Barrett recently said his judicial philosophy is mine too. Judge Scalia, in fact, packed his opinions with ideology. He wrote that the decision granting same-sex couples the right to marry was, quote, a threat to American democracy that robs the people of the freedom to govern themselves. He wanted to throw out the Affordable Care Act. He helped gut the Voting Rights Act in a ruling that's led to massive voter disenfranchisement. What's behind all this talk about originalism and sticking to the text of the laws as written is a political agenda, plain and simple. Taking away people's health care, disenfranchising voters, entrenching minority rule, giving corporations more power over their employees, legalizing discrimination against the LGBTQ community and against Black, Hispanic, Asian, and other groups of Americans. It's about cementing government control over women's bodies. Republicans could never enact these deeply unpopular policies through legislation, so they want the Supreme Court to enact their agenda for them. And I want to close by way of saying all of this is contrary to what Justice Ginsburg spent her career fighting for. It's exactly what the big rush to fill the Ginsburg seat is all about, and how this process torpedoes any opportunity for the Senate to come together on other big issues. My Democratic colleagues and I have been pleading with the majority, essentially going and saying, look, let's work together on a major COVID package, virtually pleading that we work in a bipartisan way to help people on what I have heard again and again at home is their number one concern. Mitch McConnell said, however, that it was, quote, too complicated to get done. Last week, I brought forward a bill on enhanced unemployment insurance, a lifeline for jobless workers. It was blocked. 2 days ago, Democrats brought forth a series of bills, including proposals addressing domestic violence, election security, and child care. All blocked. This nomination to Senate Republicans comes first, and absolutely everything else is on hold, gotta wait, and we see really no genuine interest to do the hard work of putting it together. So this nomination and this process are not on the level. Republicans are again breaking their word to hand the Supreme Court to the far right. And I know that because I've heard from so many Oregonians about it. Oregonians who are worried about losing their health care, their vote, and so many of their fundamental freedoms. They're worried about what this means for the future of the country. This debate is about the Ginsburg seat. Justice Ginsburg was not just an iconic fighter for the rights of the powerless and the vulnerable. She always said what she meant, and she meant what she said. We did not get that from Judge Barrett. I oppose this nomination.